This is History of Jurisprudence and Democracy, Part 6 and the final one. Again, this is now looking at international law. I want to go from the threat to the Constitution in the United States and democracy to now the international acts of the Trump administration. Talking about the Iranian conflict, where the United States attacked Iran in the company with Israel. The first thing I need to say there is that he did not get congressional authority to start the war. Therefore, from that point of view, it was illegal. So within the United States law, it's illegal. I think I can go a step further and say that under international law, it was an illegal war in Iran because it wasn't in self-defense. He wasn't being attacked. And so the same principle would apply to his attack on the Venezuelan integrity of their country, sovereignty of their country, and the removal of its head of state. And by association, the siege on Cuba, under international law, I cannot see how those acts are in self-defense. So this means that the most powerful country in the world seems to step back from world order and world rules. The war started illegally. The Iranian war started legally, and it's been going on for more than 60 days. And he would ordinarily need approval to continue the war after 60 days, even if he was right the first time. And he's simply ignoring this by simply saying there is no war, which defeats what the eyes can see. So Israel, Russia, the United States are not signed up to the International Criminal Court. But in any event, it's the under international, the law only applies to the signatories to the convention. America is part of NATO, but it's clearly stepped back from it. The point I'm making in the case of the United States is that its democracy is dependent on the rules made by the founding fathers. This administration seems to ignore that. So the domestic law cannot protect the democracy, which in terms means that he has the ability to step back from the world order as well. International criminal law and international treaties. So, international law is dependent on agreement and consent, as we know. It is, therefore, I would suggest, natural law entirely, which is built on morality and ethics. So it's important law. Right. The signatories to the international law, human rights, treaties, can enforce it only by agreement. The problem is that world safety and peace depends on the acceptance of these rules. Once a country decides to act against those rules, then there's nothing to stop another country doing the same thing. Putin's war in Ukraine was clearly against international law. The United States war in Ukraine was against international law. Neither were being attacked. China could attack Taiwan and say that they're entitled to do so as well. Jurisprudence in international law does apply in terms of its philosophy. It's not positive law, and this legal positivism has not been made by an authority or a state or a governing body. Under international law, each state is a sovereign state, which means that each country and state has supreme authority within their own territory. International law says that one state should not interfere with the affairs of another state. The relationship between these states also depends on the fact that treaties are regarded as binding between the parties that signed them. International law, therefore, is for moral basis, an ethical basis, a sense of justice and a sense of safety. It could go further and push for economic and political safe issues as well. So international law includes these treaties, these customs, as well as general principles of law. Enforcement is much more difficult at international law level. There is a provision for arbitration between the states. The International Court of Justice and other international tribunals, of course, do exist, but the participating states need to comply voluntarily with that. This was meant to give a peaceful and orderly way of dealing with disputes. The problem is that when a country steps away from this, as is happening in the world today, makes the world an unsafe place. Human rights are a fundamental aspect of international law, and so are the treaties that agree with it, and customs as well. The problem is where individual states cease to be willing to comply with these international obligations. In the United Kingdom, as I write, we are looking at removing our signatories and our obligations under the Human Rights Act in order to deal with refugees or immigrants in a way which would not be compatible. So what is the fundamental basis of human rights? The fundamental basis of human rights in international law is the Universal Declaration of Human Rights, 1948. This is the life, liberty and security provision. In the United Kingdom, Reform and Conservatives want to repeal this responsibility. The International Covenant on Civil and Political Rights in 1966 and the International Covenant on Economic and Social Cultural Rights in 1966 expand on the Human Rights Act in terms of practicalities of implication. There are other aspects in the United Nations framework, such as in climate change, the Paris Agreement in 2015, and setting out, therefore, the framework for protecting the world from climate change. Again, this is almost impossible to force when a country steps away from it. My view is that the biggest problem to jurisprudence on international terms is nationalism. There's an increase in nationalism throughout the democratic world. It's so dangerous. as there resulting tensions between states will occur, and then the risk of war and the loss of protection for humanity. There is an argument, of course, we dealt with, that said that international law is not within natural law, or legal positivism, but seems to be a rule that's just generally accepted. But I believe that we can still use the principles of jurisprudence in reasoning the importance of national law, international itself, and confirming its necessity and applicability and enforcement. You've got to think that the purpose, the fundamental principle was to the need to stop wars, conflicts between nation states, promote human rights and everything that means. Now I ask you, what is wrong with that? Why do nationalist parties want to get rid of what is that? Because let's be honest about it, when you remove these provisions, you remove it not from the people that you're trying to target, but your own people as well. Natural law theory says that the law should have universal principles of justice and morality, and that society changes and the world order does change. Yes, and I believe international law should reflect that, and it does reflect that. Legal positivism, reflecting the laws made in each state, must support international law and adopt it. In fact, in England we had the Human Rights Act, which adopted the human rights from international law. When we look at international law and enforceability, much depends, I think, on the views of the public, the societies and the individual countries. They must, in a democratic world, persuade their politicians that the greater good is to comply with the interests of morality and fairness and justice. I do think also that each society really depends on approval in what laws are being created. And societies ought to insist on international law being complied with. I do worry for the world.